the idea behind it is you can borrow at LIBOR, right?
Yes.
You can invest it 5.5% in the policy, so that you're making that one huge premium and it's carrying the policy over time. Well, if you screw up on how you finance it, you can find yourself upside down.
Yes.
And it becomes a horror story for both the owner of the policy, the agent, and then the insurance company. We had, as an example, we had like I think it was like a $50 million policy or so, where they put $10 million in. The lady was like 90 years old. There were kids who did it, and they just screwed up the financing, essentially. So instead of borrowing at LIBOR plus 30, they were borrowing at 4.5%. When crediting rates dropped down because of her age and the cost of the insurance, all of a sudden it was going to run out. Policy was going to lapse. They're blaming the agent's blaming us. We're saying it's all in writing. It becomes a huge headache for everyone. So.
Well, and that goes to the issue of really understanding the financial dynamics of the policy, making certain you understand the cost-benefit analysis, and if necessary, getting some independent consulting help so that you are not blindsided later.
Yeah.
And that's the very point that I want to make.
And I think what Pat is also referring to is that the insurance agents within the past 3 or 4 years were selling the financing of insurance policies, and they would say, we can get you $10 million of insurance and you don't have to put up a penny. And the answer to that is yes, you didn't have to put up a penny, but you had to sign loan documents on which you were personally liable, so that as long as you were making 5% on your money and you borrowed the money at 3%, you were okay. But in fact, if you were only making 0.6%, like Wasim said, on a money market fund, and you're paying 3% over here, it's not a good deal to do that. You're paying more money. But the insurance agent sold it as, oh, you don't have to come up with any money at all.
But who in his or her right mind would want to commit to a $10 million obligation and have personal liability? You're betting the entire ranch.
The kids would want to do that as long as mom is the one who's paying for it, and they're going to get $50 million.
It's also a liquidity issue.
Talk mom into doing this.
And the insurance agent, who's their friend, says this is the greatest thing in the world because he's going to get 85% of the premium for the first year policy that is written.
Yeah.
So you got the kids and the insurance agent and mom who's older, and
she doesn't know.
She doesn't know, and a lot of those policies were sold.
Yeah, it's also a liquidity issue where, like in Orange County in LA, I got to really see it a lot in LA too. You have a lot of real estate wealth.
Yeah.
So I mean, it's people that they're cash poor is not the right word, but that's what I'll use.
It is cash poor, real estate rich.
They're cash poor, but when you borrow on your real estate and you get a second, for example, and most of these are seconds, it's not a purchase money mortgage, you have personal liability under California law. You don't. That's the problem.
Yes.
Right?
True.
Yeah. You're only immune if you from personal liability if you have a purchase money mortgage on your house, and that is the purchase money mortgage. That's not the second that you take out to borrow money to put in the stock market or to buy life insurance.
Yes.
Okay. Where did this go? You killed it. Oh.
No, I didn't kill it.
Oh, you took the hockey game. Now they're going to want to see the game.
My ex-friend Richard has exposed
Let's get the car show up. Okay, any more horror stories?
I like the premium financing one. I think that's pretty good, and that's very, very valuable.
There's just a good rule of thumb, because we were talking about the in-force illustrations or the ledgers.
Yes.
And assuming a rate of return.
Yes.
From a practitioner standpoint, I think you should always, I think it's fair to assume a rate of return, but you should always run it at that guaranteed minimum also.
You run it at the guaranteed minimum. Some of the independent insurance consultants would say you do a Monte Carlo simulation and you let the interest rate vary and you see what the policy looks like, but I agree, you're just better off using the guaranteed minimum. And that way you're safe. So the solution to a lot of these foibles, and Jack wants to come back and make a comment about special needs, but the solution to a lot of these foibles is the irrevocable insurance trust. And the trust is designed to avoid federal estate taxation of the proceeds on the grantor's death. And when the premium payments are made, they're usually made under a crummy withdrawal right scenario, so that the father will make gifts to the trust to enable the trustee to use the money to pay the annual premiums, and the gifts will qualify for the present gift tax exclusion and will not be deemed to be a gift of a future interest. And the trust, of course, is an independent trust. It's going to file a Form 1041 as a complex trust. So in a nutshell, that is it. And what is so special about life insurance trusts? Well, the beneficiary of any income-producing trust can be a problem beneficiary. So we can have a problem beneficiary in a life insurance trust. We can have a problem beneficiary, a problem child, if there's a real estate trust or a trust that just owns stocks and bonds. Any funded trust can actually use income from other assets to purchase and own life insurance as long as the requisite insurable interest exists. And in the estate of Hendrick's case handout, I have a number of questions for you. And I said, what's wrong with creating an irrevocable life insurance trust, making a substantial gift of cash or municipal bonds, and letting the interest on the municipal bonds pay for the insurance premiums? And the answer is nothing.
Gift tax.
Gift tax, but above the 1 million. No, you have the 5 million exclusion.
So why use that when you can do the 13,000 per year?
True, but
put in a lot of beneficiaries. Why use up any of the unified benefits?
What if you've got sizable cash and you're not really worried? Say you fund it with $1 million. You'd rather do the crummy.
I would never do that.
Okay.
Would never do that. If I had sizable cash, I'd probably have other sizable assets. I'd rather give the stock in the closely held company or the real estate, take a discount on that, and I'm getting more of a bang for my buck.
You're getting more of a bang for your buck.
I trade the life insurance with the $13,000 per year per person, and I have a whole bunch of beneficiaries in there, both kids and grandkids, and get as many as 13,000 that I can.
Okay, and get the biggest bang for your buck that way.
That's what I like anyway.
Okay, question.
If you create this trust, can you require the beneficiaries to use the voting power without ruining the?
No, you don't. You don't require. They have the withdrawal right.
Right. You can't.
You don't require them to withdraw. You give them. They have a power to withdraw, but it's not.
And you informally tell them, to the extent you withdraw that money, it's not there for life insurance purposes, and Dad and Mom are going to revise their will and trust and exclude you because you're an ingrate kid.
Yes, you put pressure on the family member not to exercise the withdrawal rights. Doesn't anyone really look through that? And the IRS is not. I mean, they've lost. They've acquiesced to the crummy method. Okay.
How do you prove that threat was made?
Very, very difficult to do. So in reality, what happens happens is you have a crummy withdrawal right, but to the extent that an ungrateful child uses it, mom and dad make it clear to the child that it's not going to happen again because there won't be another gift.
Yeah, exactly.
Okay.
And the way we draft a lot of the trusts now is we say that mom and dad have the right to designate who can or cannot withdraw that. So they could say, next year we're putting X amount of money in there and Susie does not have the withdrawal right anymore.
But they can do that on
In the original trust document.
Oh, in the original trust document.
When they created the original trust document.
Now, as with any permanent trust, we always have the problem of the settler's control strings, don't we? I mean, you talk to any parent or any grandparent, and they want to be a trustee or they want to have certain powers over the trust. And the problem with these powers is they can cause an income tax inclusion problem or an estate tax inclusion problem. And under Section 2042, the regulations effectively would make, if you have a settlor who is also a trustee, the regulations would effectively deem the settlor or trustor to have an impermissible incident of ownership under the Section 2042 regulations. And this is why the Hendrick case is such an interesting case. Let's turn to that case just for a little bit. In Hendrick, who was the settlor or the trustor? Now remember, who's a practicing lawyer with a Master's of Law in Taxation from New York University, one of the finest tax programs in the United States. He was a practicing tax lawyer. So how did he create this trust? Was he the settlor? No. What did he do?
He made the bank.
He made the bank. He made the bank the trustee, the sole trustee, correct? Did he reserve any powers at all?
No, I think there was some issue because he was a related party to the bank, but in general it looked like he was totally removed from it.
But he reserved the right to remove the bank and appoint another bank as trustee, and that's permissible. So he did reserve that right. The Internal Revenue Service didn't question it. Did he obligate the bank to use the cash gift to buy life insurance? No, the trust document was permissive, wasn't it? It just said, you, Mr. Trustee, can purchase insurance upon my life. Who are the beneficiaries of the trust? Anyone remember? Wife and children, correct? So he creates this trust document. He's not the trustee. The bank is the independent trustee. The beneficiaries are the wife and children, and he does reserve a power to remove the bank and replace the bank with another corporate fiduciary. That's okay. He doesn't require the trustee to buy a policy of insurance upon his life. He allows it, and in fact, that's what the trustee ultimately did. Was there anything odd about the bank in this case that you remember? How much experience did this bank have with life insurance trusts? They had never done it before. Isn't that interesting? I mean, why would you go to an institution that knew nothing about the animal you were creating. Doesn't this strike you as strange? I have no idea. I was rather surprised. So he has to explain to the bank what he's doing and why he's doing this, but that's basically what he does. And he makes a deposit of only $5,900 to get the trust going. It says that, and what's important, the decedent did not condition the establishment of the trust on the bank's commitment to acquire life insurance. Okay, I mean, the bank could have taken the money and bought stocks and bonds with the money. But there was a gentleman's agreement, not in writing, that the bank would use the cash contribution and purchase a policy of insurance upon Hedrick's life. Now, who arranged for the insurance physical? Who signed the insurance application? The trustee. Was there an application that the decedent had signed in advance of the trust? In other words, did he get the insurance application, sign it, and then say, oh, I'm going to go to the bank and create my irrevocable life insurance trust? Or did he go to the bank, create the trust, and then deal with the insurance application? The bank signed it, and then he went for his physical. He didn't transfer rights under a pre-existing application. So afterwards, he creates the trust, he funds the trust, he then asks the bank what he asks the bank to do that. The bank doesn't have to do that, but the bank decides to go along with the informal plan. The bank contacts Massachusetts Mutual Life Insurance Company, arranges for the physical, signs the application as the owner. Eddie has his physical, correct? Okay. Interestingly, what happened 3 months after the trust was established? And there's really no discussion by the court on this. 3 months after the trust was established, the decedent joined the bank. He joins the bank's board of directors, right? And he became a member and chairman of the trust committee of the bank. So why didn't the Internal Revenue Service say, oh, wait a minute, there's a trust, the bank did everything okay, but now the decedent is on the bank's board of directors, he's on the trust committee. Why couldn't that be an incident of ownership cause an inclusion in his gross estate?
Too many vehicles in the way?
Well, now I'm looking under my estate tax regulations under section 2042. The term incidence of ownership is not limited in its meaning to ownership of the policy in the technical legal sense. Generally speaking, the term has reference to the right of the insured or his estate to the economic benefits of the policy. Thus, it includes the policy to change the beneficiary, cancel the policy, assign the policy, revoke an assignment. If Eddie Hedricks is the chairman of the bank's trust committee, couldn't he exercise some impermissible influence over the bank with respect to the policy?
He doesn't have the economic benefits.
Maybe he could induce the bank to borrowing on the policy for the trust benefit.
If he was a major shareholder, maybe.
I I have no idea. But it's interesting that this is not discussed in the tax court's unanimous opinion, and this was a reviewed opinion, reviewed by the entire tax court. So it's a very strong opinion. It's not the opinion of a single judge of the tax court. It was written by and reviewed by all the tax court judges. So I find this to be interesting. All right, so the trust was reviewed every 3 or 4 months as part of the bank's routine procedure. And how did Eddie die? Tragically in a car accident. And what was paid to the trust? $378,701. So Eddie did a lot of things well, and the problem of this trust is probably not going to materialize again. But the reason this case is a nice case is because it reinforces the need to have an independent trustee. You go to the bank, you have an independent trustee. I have a life insurance trust. I have an irrevocable life insurance trust. I was the trustor or the settlor. The beneficiaries of the trust are my wife and my nieces and nephews because we have no children. The trustee is my wife and my cousin, who is a certified financial planner. All right? So, but I did some things I probably shouldn't have done. It's water under the bridge. I created the trust first. And then I took pre-existing policies on my life and I transferred them to the life insurance trust. Signed all the paperwork, all the documents. That's okay, but what's the risk?
3 years.
Oh, what's the 3-year rule?
If you die within 3
If
years.
I die within 3 years, everything is includable in my gross estate. But I willingly took that risk. If I were doing it from scratch, I probably should have followed Eddie Hedrick's blueprint, but I didn't. I have these pre-existing policies, and my wife was the beneficiary, and I said to myself, well, what's my wife going to do with all this money? I really want my wife to be in the driver's seat, but I'd like to benefit my nieces and nephews also, and so that's why I created an irrevocable life insurance trust with my wife as a trustee, my cousin is a trustee, my wife is a beneficiary, my nieces and nephews as beneficiaries, and I accepted the risk of the 3-year rule under Section 2035. But that's okay. That 3 years ran some time ago. And I've crossed the T's and dotted all the I's, and so everything is fine. I'm watching my policies. Why? Because I have universal life. So I realize that I'm young now, but when I'm 80 or 85, and I may just cash everything in, and the trust will be funded with cash. I won't do that. I'll tell my wife and my cousin, hey, I think you ought to cash in the policies, and the trust will be funded with cash. So that's probably the plan. So in the questions and comments, you can see that I have some questions and comments here. It was interesting. One of my questions was that Eddie's medical exam occurred one day after the trustee executed the life insurance application. What if Eddie's medical exam had been one day before the trustee's execution? If it had been one day before, maybe there's an equitable interest in the policy that triggers the 3-year rule, right? So it was good
that he had his exam and did all the paperwork afterwards. These little details can be very important. Now, I do have a niece who does have some special needs, and she's the beneficiary of this trust. And so the trustees, upon my death, the trust will collect a lot of money. The trustees can distribute income to her. I didn't make any special provisions for her. I figured she'll just get her pot, and if she blows it, she blows it. Is that a good idea or a bad idea?
I think it's a bad idea.
Okay, what should I have
The
done?
reason that I think it's a bad idea is that I'm not wild about the special needs trusts.
Okay.
The reason I'm not wild about the special needs trusts is that very often the people who need the special type of care qualify for California programs, and the California programs are the best programs around. And you can't get into the California programs unless you have no assets. So that if you have assets, California says you can't get into the programs, and there are no other programs that are comparable or as good as the programs very often. Second, it occurs to me that with California needing money, at some point in time, California is going to say, if you are in any way, shape, or form the possible beneficiary of a trust, that trust must exhaust its assets first before we will cover you under our California plans. So what I prefer to do is the other aspect that Richard alluded to, and that is the trusted nephew, the trusted friend, the trusted family member. I leave the money to them, maybe two of them in joint tenancy, and say, that's money, it's yours, but I really want you to use that for your sister, your niece who needs the help if it ever comes down to it. And I trust the people, and I trust the people more than I trust our government.
Now, in my niece's situation, she's only special needs because of a possible or a birth defect. Her IQ is about 90. She has trouble graduating high school. But with an IQ of 90, she can be productive, but she's never going to go to university. And so do I trust her two brothers who are college graduates and doing very well? Do I trust them to take care of their younger sister? I just made her a beneficiary of the trust, and other things being equal, she'll get her 1/5 piece of the pie after my wife's death. But
again, I like the concept of trusting the brothers.
Just trust her
the money
brothers.
is there, and I trust the brothers more than I trust the government.
Okay.
Is it possible with the California programs you just mentioned that one day they might allow people who do have net worth to become part of that program, but buy into it or pay somehow pay for it?
Well, they'll say you have to spend all the money first. So if you have to do that, why not leave it to the brothers, because you've spent the money and it's gone? Have the brothers there having it for her to cover her to the extent California is not doing it.
Now, yes.
Professor Richard, on the flip side of what Jeff said, with all the budget problems that California's been having, how do you even know that these programs that are so great will still be around? And would it be managing your risk to put the money in the trust anyway, aside from
If that doesn't happen, I got the two trustworthy
yes, if you
brothers.
have your brothers, so I guess that takes care of that risk. So.
Except that one of my nephews is a total goof. I mean, I'll trust him to take care of his sister, but I don't know what he will wind up doing. He's now applying for law school. So, if he does well, great. But I guess I could.
I hope you're not saying that because he's going to law school that qualifies him as
No.
That's not one of the criteria that we're focusing on.
But it occurs to me, Jack, that I could probably amend the trust and just
Probably not.
give the trustee
Probably not,
discretion.
probably not, because it's an irrevocable trust when you set it up.
Okay.
I don't think that's an administrative power anymore, I think that's more than an administrative power, I don't think you can amend that.
It's very interesting. I'm the beneficiary of an irrevocable trust created by my parents and my father's testamentary trust. And we have had the trusts, each trust has been amended 3 times by the Superior Court with very interesting amendments.
And each time you had to state that it was merely administrative,
No.
or that there were changed circumstances.
We went through changed circumstances and we
I
got
don't see changed circumstances.
We got
through this.
beneficiary consent, and the judge said this is fine.
I don't see that happening with
Here,
the niece.
okay.
If you appoint a guardian ad litem on
Yes.
behalf of the niece with the IQ of 90, that guardian ad litem is never going to agree to that.
The Superior Court allowed the guardian ad litem to be my brother, her father, and went along with everything, which is interesting. Now, maybe that was just that one particular judge.
I think so.
Okay, if you were the judge or the probate referee, you would have put a red X through the entire petition, right? Okay, but it's interesting that under California law,
Not only that, but maybe if I'm the IRS agent later on,
Yes.
I say that you retain the right to modify the trust under 2038 to alter, amend, revoke, or terminate, and therefore it's included in your estate anyway.
it's interesting that California law allows for the modification of
Change
irrevocable trust.
circumstances.
Change circumstances is one, but the other is just beneficiary consent with the guardian ad litem.
It's more complicated than that.
But
I think it's more
that's what we did.
complicated than that.
But we were able to do it, not
Yeah.
once, not twice, but 3 times. And I agree, there's always a risk that the Internal Revenue Service could say that everything is includable in my gross estate or my mother's gross estate because of what the beneficiaries did.
Maybe if you had a lady judge, it was under the Lionel Richie song, once, twice,
No, it was a male judge. It was a male judge. Okay. How many of you know about spin life or stranger-owned life insurance?
We talked about that a little bit with
Okay.
the insurable interest.
That's why I have the investment warning here. There is a company in California that is selling these policies actively. They are marketed. They have the permission of the insurance commissioner to sell these policies. But I've always been concerned about the insurable interest problem.
That law is changing, and there are a bunch of cases back east in Virginia, New Jersey, and Maryland dealing with this issue right now. They're
How do
just
I
evolving. They're absolutely evolving.
get this stuff right here?
Open that up.
Yeah.
Press visiting rep that one.
Okay. So that's why I have that investment warning. The
Yep.
insurable interest rule
Yep.
is alive and well in California. The Wall Street Journal has been chock full of articles about the risks of being an investor in a pool of insurance policies on someone else's life where you don't have an insurable interest, but these things are being sold. Have you had any experience?
Yeah, it's a huge issue. When I first saw it come up, like probably 3 or 4 years ago.
Yes.
Luckily for us, it seems like it turns out to not really be a good investment, just because people are living so much longer.
Yes.
So from the stranger standpoint, you end up having to put more in, so it really reduces your return. But it's an ongoing thing.
This was talked about at the USC Tax Institute last year, as I recall, or maybe it was the prior year. But it's amazing that people are doing this all the time, and it's the investors who are wind up losing because all of the proceeds of a life policy are now tied up in litigation. So you have these people who have paid hundreds of thousands of dollars to participate in this life insurance pool. One case in the Wall Street Journal had someone who paid several $1 million, and he has nothing to show for it except the litigation headache. Okay? So that's just a warning. I have some references here. Here's the website to the insurance forum that you can go on. Some of the graphs were from the California Trust and Estates Quarterly. Jack is going to put this on Blackboard, correct?
Yes.
He's going to put everything on Blackboard for you, so you can access Blackboard. I don't have to send you email, and you can download all of this material to your heart's content.
Should be there by next fall.
I'll have some. Thank you. All right, questions about this? No questions? Yes.
I have a question about the irrevocable insurance trust.
Yes.
You said that the trustee needs to be independent?
The trust, you want to have an independent trustee so that, because if I'm the grantor, I have an incident of ownership if I'm also the trustee.
But you said your wife is trustee. Isn't that so close that it's...
No, because everything was funded with separate property. I forgot to mention that. It was funded in part with money that I inherited from my father, so it's separate property. And my wife signed a separate property acknowledgement, and that's why she became a trustee. That was one of the documents along with the trust. Now, one of the problems I have with my own estate plan, and I'll share this with you, it's too complicated. You know, everyone talks about the dynasty trust and what to do with children. I don't believe in any of this stuff. I think you just give the kids money outright, and if they blow it, they blow it. Because frankly, I can't deal with all this stuff. When Alan had my wife come in to sign all the documents, my wife said, if you're going to show me anything over a couple of pages, forget it. And there was this 50-page insurance trust, and I told you that she went absolutely bananas. And then when it came time to do her will, she said to my attorney, just have Richard write my will and sign it. I don't want to be bothered. And we've been married a long time. I'm telling you now, there are some wives that want to be intimately involved in all aspects of the planning process, but not my wife. She hates paperwork. She won't read anything that she signs. And she wants me to sign, and she told this to the lawyer. She said, I'm not reading any of this crap. I'm late, and my horse is waiting for me. I want to get back home. And there are some women like that. But it pays to pay attention to detail. Details matter. But I look at these 50 and 60-page documents, and I say, this is ridiculous. All this mind-numbing detail, who can comprehend it? Who can administer it? Yeah, but are you going to be there to administer it?
Yeah.
More reasonable.
So I do like simpler, user-friendly documents because lawyers are not necessarily the trustee. And you have to have a family member as a trustee be able to read and understand and deal with the documents.
The president of Calcan Foods, which was a huge, closely held corporation in the harbor area, felt exactly the same way. And he said, I don't want these complex lawyer documents. So he drafted up something very simple and straightforward himself. It was in litigation for 15 to 18 years after his death. Because the court said, we're not used to this language, we don't know what it is, we haven't seen it before, we have to interpret everything. They had everybody suing all the time, 15 to 18 years in litigation. So it's a trade-off. You want it to be simple, but you also want to use language that the courts are using.
You don't do it yourself.
It's kind of like saying, I want my car to be fixed, and the guy says, I'm going to put it on this computer, and you say, no, I don't want you to put it on the computer, just listen to the noise and figure And he says, well, maybe we used to do that about 40 years ago with the cars. We don't do that right now.
So there is a,
You have to do it with the times.
there's a trade-off of document complexity
Yeah.
and the
Yeah.
detailed provisions, and you need to be able to think about administration and understandability, so you have to use the proper legal language.
Now you pick on what I'm gonna say in terms of the employee benefits.
Which I've
I
long.
start out and I have a little preface for employee benefits. And the preference for employee benefits is that it crosses over so many fields that no one does a good job. Crosses over so many fields that nobody does a good job. What I mean is you've got pension law, you've got labor law, you've got divorce, you've got family law, you've got estate and gift tax law. If you find anybody who does all of those areas of the law, he's a fibber. It's just too hard. It's a fibber. It's just too hard. You don't cover all of those areas of the law. And unfortunately, these employee benefits cross over all those, so lots of times nobody really does a good job. In the first one, we've got XYZ Corp. Closely held provides medical coverage under a self-insured accident and health plan for key employees. These key employees own a minimum of 10% of the stock. What are the tax consequences of such a plan, both for the corporation and the shareholders? We like the medical reimbursement plan if it works. We like it because of the fact that the corporation gets a deduction for the medical expense, and it's not taxable income to the employee.
This is a 104, a section 104 plan, correct?
I think it's 105.
Oh, okay, 105, okay.
But I'm just guessing.
Okay.
The problem is that it's no good in regard to an S corporation. A 2% shareholder or more in an S corporation is taxed. So you can't really have the employee benefit plan, this medical reimbursement plan is what we call it, a medical reimbursement plan under section 105. So it doesn't work in an S corporation, which is typical to benefit a 2% more or more shareholder, which is exactly the person that you want to benefit. So that's problem number one. Turns out to be income to them. Problem number two is if you have a C corporation, a regular corporation, you can have the medical reimbursement plan provided it is non-discriminatory. At one point in time, long time ago, we used to have a plan for the doctor that said the doctor's kids are covered for orthodontistry, eye problems, medical reimbursement for this, this, and that, 100%, and no other employees are covered. We can't do that anymore. To the extent you have that plan for yourself, you also must have it for the employees. So what can you do? If you have a regular C Corp, you can have the plan say, we'll cover everybody for the first $15,000 of expenses. So if your family has the $15,000 of expenses and the employee or her family has $1,000, okay, so you spend an extra $1,000 and it's worthwhile. When the employee has $15,000 and you only have $2,000, you get rid of the plan. That's typically what happens.
Jack, that's what we had to do with the family corporation, because we had a C Corp with about 12 employees, and we were told we had to cover everyone, and eventually the premiums and the cost got too expensive. We just got rid of it.
Yeah.
Isn't there also a limit of 55,000?
Is there a limit of 55,000? I don't think so. Under term?
Yeah.
Okay, I'm not into group term, remember, I'm talking the closely held corporation that you're doing for yourself, family, and so on, regular CPA. Okay? The point in 13.1B is again that it's got to be non-discriminatory. If there's a separate plan for the rank and file, like an HMO plan, you can have different types of plan as long as they're non-discriminatory within the categories. 13.2, H dies, he has 1.8 million in a pension plan, the wife is named as the beneficiary on the form designated by the husband. Should she take the proceeds in a lump sum, in an annuity, roll them over into a spousal IRA? Would it have been better if he named his living trust as beneficiary? In a lump sum, probably not. In an annuity, not unless he's concerned about being a spendthrift or she's concerned about being a spendthrift or Jerry the Gigolo.
Jack, the annuity, does the husband get to designate the annuity? Can you say that on the form?
No, if it's
No.
in the pension plan, she has an absolute
She
right
has
to
an
do
absolute
that.
right, okay.
As the spouse.
Unless he's worried about it.
13.2.2, should she roll them over into a spousal IRA? Yes. First of all, they qualify for the marital deduction for estate tax purposes, so there's no federal estate tax on it. Second of all, when she rolls it over into the spousal IRA, it's not taxable to her from an income tax point of view until she starts to take the money out in the future. Third, the money in the IRA accumulates tax-free for her because it's a tax-exempt entity. And number four, it probably is creditor protection and exempt against creditors because of the fact that it came from the pension plan. Remember Mark Clark's speech that as long as you could trace the proceeds from the pension plan to the IRA, it was probably safe.
Professor Barcal, is there a limit on the spousal IRA?
No. There's not a limit on the amount going into the spousal IRA. So that if he had $4 million in the pension plan and she was designated, she could roll it over into the spousal IRA.
Can you repeat the first benefit?
Since I just made it up, probably not, but maybe somebody could help me. So the first one. Qualifies for the marital deduction, so no federal estate tax.
So if
And if people have, 1, 2, 3, and 4, and you tell me what it was, I can paraphrase it again, but as far as repeating it, no.
I'm sorry, I missed the answer for number 2 being an annuity. What was the answer for that?
If she likes it, or if she's a spendthrift and she's concerned that Jerry the Gigolo might get the money, then maybe the annuity's okay too.
So, can you use a spousal RIA, like if you have a high risk of creditors coming after you, like if you have
Yes.
a closely held business
Yes.
with a lot of risk? Okay.
Yes, just as you could from a pension plan. It's the same type of protection. As long as you trace it and don't put it in another IRA, you put it in the new IRA that you create. Would it be better if he named his living trust as beneficiary? No. Only as a contingent beneficiary. Name the wife first and the living trust second as a contingent beneficiary. 13.3, he's got $2 million in profit sharing plan at Micro Squish. Attempt at a very clever name. H and W get divorced. Can W just take a half of the million in a community property state like California? No, she needs a
Quadro.
quadro.
A what?
Quadro. Remember that from last time. QDRO, Qualified Domestic Relations Order, which basically says, the court says, split it in two. You take your money, and then it goes tax-free. .4, A has a very large lot of history here. First of all, at one time, you could take a lump sum and it was 10-year averaging. You could average it over 10 years. That got repealed. Then they said you can average it over 5 years. That got repealed. Then they said you can roll it over into an IRA. That's still okay. Creditor protection, you have to look at the pension plan being more absolute than the IRA. And then we have a wonderful little catchy phrase, which was too little, too much, too early, too late. And we'll go through each one. Too little was, there's a penalty if the yearly distribution is too little on a life estate calculation. So the too little rule says there's a penalty if the yearly distribution is too little based on a life estate calculation. You have to take it out over your life expectancy. That's the too little rule. The too much rule is there's a penalty, an excise tax of 15% if you take out too much. That got repealed.
1%?
That got repealed. That got repealed. 15% penalty got repealed. But that was the too much rule. There was a penalty, an excise tax of 15% if you took out too much, it got repealed. Next, the too early rule. The too early rule says there's an early withdrawal penalty of 10% if you take it out before age 59 and a half. The too early rule, early withdrawal penalty, if you take it out before 59 and a half. Next, the too late rule. The too late rule says if you distribute it by age, you must make a distribution starting by age 70 and a half, and if not, there are penalties. So that's the too little, too much, too early, too late. That's the way the people in this area used to talk about it over the years. Yes?
Is it possible at all to do an early withdrawal if you have like a repayment plan?
Is it possible to do an early withdrawal? You can do an early withdrawal for some medical stuff and for this and for that. There are all sorts of exceptions. This is just a big one.
Do you think it's not advisable? Like I was always told that you could like do it for a mortgage, but like
I don't like to do it because you're taking it out of an entity that's allowing tax-free buildup of money, and it's there for creditor protection in the end.
What was that?
So I don't like it.
How about the estate actually catches in his pension? Wouldn't she take it as a tax free, not taking a tax on it for less than $5 million? Not put any on that.
You're saying if once more, what happens?
Like when he dies as a state, it catches in his pension plan.
She takes the money in a lump sum.
Yeah.
She's got income tax.
That's not exact.
No.
So the state can't cash it for him and put it in his estate.
She is the beneficiary. She is listed as a beneficiary on the beneficiary designation if she takes the lump sum income tax result.
Now, if she's a beneficiary, will it still be included as part of his estate? No?
It's still an asset of his estate because he was the owner, yes.
That's the same thing like life insurance.
No, life insurance has funny rules like incidents of ownership. Pension and profit sharing says, did he own the asset like he owned a Mercedes automobile, like he owned a piece of real
estate plan. It's think of it as a standalone legal entity, a standalone complex trust, just for life insurance policy purposes.
And that doesn't get included in
That one.
if I remember correctly, that one doesn't get included in your estate.
The life insurance trust?
If you've done it properly,
If you've done it
and
properly.
the owners are the kids or the trustees, that's correct. But if he retains some incident of ownership, then you have a problem.
You could just make a cash gift to your children. You can make a cash gift to each child and say, I'd like you to use this money to take out a policy of insurance upon my life. You're the owner, you're the beneficiary, and as long as you don't cash in the policy, every year your mother and I will make cash gifts to you to enable you to make the premium payments.
Where the kids are the owners directly.
Yes, yes.
And you also have to tell that child, don't die.
Yes.
Because if you die, then